Hi, my name is Tom Spiggle. I'm with the Spiggle Law Firm, where we represent people who've been wrongfully fired or afraid that they might be. Today, I want to talk to you about something called a discovery letter. A discovery letter is something that we provide that allows people to send a letter to their company in order to see what response that they'll get back. So let's break that down a little bit. In an employment case, right, you've had something that has happened to you, right? You've been fired, you have something going on at work. There's some reason that you are watching this video. And what you're trying to do is you are trying to get to some kind of end goal here, right? This can be any number of things. This could be a better severance agreement, so money. It could be that you want a reference, release from a non-compete. There are any number of things that you might have as your objective. But in order to get here, you first have to, as it makes sense, you've got to contact the company and tell them what your position is. And generally the way that happens in an employment law case is the attorney or someone will send the company, with us it's the attorney, send them something called a demand letter. And as it sounds, a demand letter is one where the attorney sets forth your position, tells the company that we believe that there's been a violation of the law, and that the company should give you whatever it is that your objective is, whether it's money, release or non-compete, a positive reference, or some combination of those, in exchange for you releasing your legal claims against the company. This is the traditional way that this happens. Now, there are a bunch of different ways to do a demand letter, right? A demand letter can be, if you go all out, you can do a 10-page, single space with witnesses and all kinds of bells and whistles that you send to the company. And in some cases, that can be appropriate. But here's the thing. What you are really after with this demand letter, and what one of the big pieces of value from it, is you want to get a response from the company, right? And we're going to call it here company's first true response. What is a first true response? A first true response is a response to the initial demand letter from the company, usually by their attorney, and usually by an attorney with some knowledge of employment law. And what that does is that gives you an indication of how the case is going to go. It doesn't spell out everything, but you get some indication of what the negotiating posture of the company is. So, and you need that first true response because in order to propel yourself from where you are now to where you want to be, you have to have something to push off of. If I want to jump up off this floor, I have to have something to react to. The first true response here is what you react to that will get you to your goal. To get from here to here, right, it's developing the case, it's talking to the attorney, it's figuring out what laws may have been broken, but to get all the way through, you have to have a response from the company. Now here's the trick. Getting the first true response, and let me say, this first true response will not be the actual, it's not the bottom line from the company, right? I mean, if you think of this as a poker game, this is their first hand, right? It may be a low ball, you know, they may be bluffing, but this is their first hand. And in order to get this response, you need to have an attorney at the company review it. Well, that's sometimes can be easier said than done. If you send a letter on your own, kind of a DIY approach, and sometimes that can be valuable. There are times that can work out, and we actually have a program called Legal Leverage that can help you with that. But one of the limitations of it is if you send your own letter, it doesn't get in front of the company lawyer or somebody with knowledge who can give you the first true response. If it goes to HR, if it goes to somebody in the company leadership who's not an attorney, if it doesn't come from an attorney, if the demand letter is not from an attorney, you may not get any response, or you may get some response that isn't the first true response because they haven't been able to appropriately evaluate it. Again, imagine you're at a poker game, right? You're a great player, you've got a great hand, and the player that sits down next to you is a 6-year-old. okay, you're going to get some response from that 6-year-old, but it's not going to be a very good one. And it doesn't matter how good your position is, because that 6-year-old probably doesn't know how to play the game. And so you're going to get a response, but you're not going to get the first true response. So enter the discovery letter. The discovery letter that we offer is designed to get you this first true response from the company in a way that is more cost effective than if you sign a full retainer. And by that, I mean you just hire the attorney and you say go, in a more cost effective way than if you do that. Now, that's not to say that you shouldn't, if you are thinking about it, sign a full retainer. There are times when that is advantageous. But here is one of the advantages to the discovery letter. The discovery letter that we provide is the minimum amount necessary to get this first true response. And by that I mean, the discovery letter is a 3 to 4 page letter that the attorney is going to help you write, that will go out on our letterhead, that is designed to get this, the first true response. What it is not a letter in which the attorney sits down with you, goes through all the relevant facts, spells it out in painstaking detail in the letter, maybe contacts witnesses, maybe does some original research. It's not that. Those letters can be very good and useful in some situations, but as you might imagine, they can be more expensive. And here is one of the advantages of the discovery letter. Sometimes a 3 to 4 page basic letter will get you the same first true response as a letter with all the bells and whistles. And the advantage of that is, once you get that, if it in some sense is what you're looking for is that first true response, and it doesn't matter if you've got a 10-page letter or a 3-page letter, what you're trying to do is get this, because the key is, once you get this first true response, you can tell from there what the battle looks like after that. Let me give you an example. If you send the letter, you send the discovery letter, you get a response back from the company, and the response is, we've reviewed this. This is a very typical response. We've reviewed this. We don't think there's any liability. We are confident that the company would prevail in trial. However, in order to resolve this, we are willing to offer whatever number it may be. Okay, that's a great response, and you know then that you're at the card table, right? You may not win the hand that you want, you may not get all the chips, but you know you're in the game. And that's a very positive response, because that means there's probably productive negotiations that can go on after that. What if you get a response that says, we're not going to pay you a dime, and we'd rather pay our attorneys $250,000 than give you any kind of relief? Well, that may be a bluff, okay? But it may not be. And it certainly suggests that while you might be able to get a resolution with your case, it's not going to be a quick one. And there's going to be some back and forth with the company. It might involve further litigation, filing with the EEOC, possibly filing in court. We know it's not going to be an easy gig. You also, another thing that you get in the first true response is you get the company's story. Something about what happened, right? And that can be useful because there are a couple of things. One, you might actually learn things that you didn't know. Let's say, for instance, that the company fired you and they claimed that it was for poor performance, but you didn't think you were performing poorly. But in the company's response, they share some information with you that your boss has 5 memos to file where he is criticizing your performance. Now, maybe he's wrong about that, and one can contest that, but it sure looks like they had a good faith reason for letting you go. Well, that's useful information, and useful information for you and your attorney to decide how far should we push this. Another thing that you can get is, from the company story, is whether or not it's something called pretext. Or in layman's terms, BS, right? One of the things that the company will do in their response, again, they're going to have to say something, is in their story, sometimes they will blatantly lie, right? They'll say, well, we didn't let them go for a discriminatory reason. We did it because of poor performance. But they're not able to provide any evidence of that. It's just a blanket statement. And you know that you've got 4 folders full of positive performance reviews. You also know, for instance, that you are the only woman that was let go from the company, right? They kept all the men on board. Well, that's all of a sudden their story is starting to look a little fishy. And this is a key factor that courts look at, right? Because it's rare that a company comes forward and says, oh, you got me, we violated the law. They've always got some kind of story, and a lot of times it's pretext. It's a made-up story. And so in their first true response, we're going to get a sense of one of these 2 things, right? Whether it's pretext or whether there's some useful information. And again, these are all things that your attorney, after getting the letter back from the company, can review with you and give you a much better idea of what the path forward may look like. Prior to getting the company's first true response, we're all just, even if it's experienced attorneys as we are, we're making our best educated guess, but we're all staring into a black box. We just don't know until we get that response back from the company about what the case may look like going forward. So that's what the discovery letter gets you. It's a flat fee product. We offer it 3 to 4 pages. Again, it's not the letter for you. It's not going to be the 10-page, single-space, everything you want letter, but that's okay. You don't need that. You just need a shorter letter to get the first true response. And then you can later, if it seems warranted after talking to your attorney, you can send a follow-up letter. If it makes sense after talking to your attorney and you want to invest the resources, that you want to send a more robust response after that because we think we're going to be able to settle it, this doesn't foreclose you from later going forward with a more robust response to the company. But the discovery letter can get you that first true response with the minimum effort and cost necessary to do that. Now, a couple of things to think about with the discovery letter. It's not going to get you to the finish line, right? It's not going to get you here. Because after you get the first true response, there's got to be a response from your attorney to wrap this up or to move the ball forward. So after the discovery letter, what will happen is you will have a conversation with your attorney based on the very valuable information we've gotten from the company now. The attorney's going to talk to you about what would it take to get you here. And then you get to decide. You get to decide whether or not it's worth the investment. You get to decide, perhaps you decide it's not worth pursuing at all because you get a very robust response from the company. Doesn't look like they're going to settle easily, that they're going to fight it, even irrationally. And you may decide, you know what, that's just not worth my investment. Now that I know, before I didn't know because I couldn't get this first true response without sending this letter, but now I know, I've decided I'm not going to invest the resources. You also, it is possible with a discovery letter that you get no response. It's rare, but it occasionally happens that even when an attorney sends a letter, a company just won't respond, or they'll give some very short response, maybe a short letter saying, we've received your letter and we are now investigating it, and then they go quiet. That's a frustrating answer to get. However, it is still useful. It suggests one of 2 things. A, the company doesn't know, they're not properly evaluating this, right? They're a mess. They can't even get it together to send you a response. Or they are so confident, maybe so aggressive, that they decided that the power move is no response. Or, hey, fine, if you want to, we'll see you in court. Frustrating, but also a valuable response, because then you know, which you didn't before until you got this, you know what the company's, how they're going to act. You know there's not going to be a quick settlement. You know that in order to get a settlement, if it's a discrimination case, you're probably going to have to file at the EEOC. You know that the timeline is going to have to be extended. Again, all steps that you may want to take, that may make sense to take, but you don't have that information until you send the letter and get the response or no response. So you've got the response back from the company. You can have a reasoned conversation with your attorney and then decide where you go from here. Do you put more resources into it to press forward? Maybe your attorney looks at it, this is entirely possible, and says, you know what, this is a positive response from the company. I think we're going to be able to get this settled in a range that will be acceptable to you, and we probably can get this done with maybe another letter, maybe a couple of phone calls, and they can give you an idea of what that cost would be, and it's going to be resolved fairly quickly. That's a great outcome and entirely possible. Maybe, again, the attorney talks to you and says settlement is possible, but it's going to be longer, and these are the steps that we're going to have to take, and this is what it's going to look like going forward. Or, this response from the company is either non-existent or very aggressive. We can continue to push, but it's going to require a lot of effort, and this is what the steps are and what the cost is going to be to you. And again, there's no guarantee on our end, on the firm's end, but it is possible that once we get the first true response from the company, that we offer you a contingency fee retainer. That is, you don't pay us any additional funds unless and until you recover something from the company. Again, no guarantee of that, but that may be an option after we get this first true response. So again, this discovery letter with the minimum effort and cost necessary gets you this first true response, which is the most valuable information to decide what the best next steps are for you. If you're interested in pursuing this, feel free to talk to anyone in our firm. We'd be happy to get you set up with this. And I wish you the best of luck.